see me taking no cash, no $2,000 worth of lottery tickets, nor no cash from Speedway. Period. There never was no cash taken out of the drawers at all.
We have for sentencing today.
Yes, Your Honor, I have reviewed the report and recommendation with Ms. Pitts-McGoy. So the only modification we would make that I'd like the court to note that Ms. Pitts-McGoy has indicated to me that she does take responsibility for taking some of the items identified in the police report, or with her statement to the probation department. She apparently was indicating that there were certain other items that she did not take responsibility for. That said, she certainly regrets her actions and asks the court to accept the recommendation.
All right. Ms. McDuffie?
Your Honor, not too much I agree with the recommendation. I'm just scanning this quickly to try to get a handle on what the exact amount is going to be. Obviously, we need to pursue that further and get verification for that fair amount that was agreed to in the plea agreement for restitution. But other than that, I agree with the recommendation.
Well, excuse me, it never was no amount agreed to in the recommendation. That was something that...
Ms. McGoy, you're going to be given an opportunity to talk, but this is not yet that time.
And just to be clear, Your Honor, the plea form states that a fair amount is to be paid. So I was referring to those words, no specific number, but that number had yet to be determined.
I was only speaking because he was not my attorney, so he's not familiar with my case. I'm familiar, so I don't want nothing to be placed on the record that's not true. And he's talking, and he has not even been my attorney this whole time. So I will correct you if you're wrong about something, because I don't want something to be on the record that's not true, and then it be something different. That's all I was doing. So my apologies, Your Honor.
So the plea form says, which is the plea form that your attorney at the time signed, says that you must pay reasonable restitution. Is there something you would like to say prior to sentencing, ma'am?
No, ma'am.
So, Mr. Liebwald, are you requesting a restitution hearing at this time?
Your Honor, my understanding is that would depend on exactly what the amount of restitution being requested is, and we do not have that number at this time.
And how do you plan on coming up with that number, Ms. McDuffie?
Your Honor, I'm scanning this report. Obviously, this is something that was remanded, so I wasn't involved in the case when it was pending in the PCC stage. So I'm trying to get some clarity, and I don't have the ability to do that right now with respect to any items that might have been recovered, returned. I just don't know that at this point. Most of this is apparently cash and lottery tickets. So I'm assuming that the cash is not something that was recovered because it wasn't something that was caught at the time and prevented from leaving the establishment. But I just wanted to follow up with some of the other folks that handled this case previously to get any more details that might be there I'm not aware of. So we can set it for a hearing because we one way or the other, we need to come up with a number. So I don't, it may be that we need one regardless.
Well, I'm going to and Speedway submit whatever documentation that they believe they have. I don't know how they can determine this.
When it comes to the lottery tickets, I know I've prosecuted some other cases before in another court where we were able to actually track the specific ones that were missing, reported missing, because there's very strict accounting that goes between that and the state office. So that could take me a bit of work to follow up on, but I may be able to get that information too.
Okay. And then they're claiming $1,200 in general merchandise and then another $210 in Newports. And is there a way that there was a video? Correct?
It looks like there is at least some surveillance screenshots from video, and I can't make it out because it's a little bit tiny on my screen, but it looks like there's some ledgers or some other accounting of some sort of items from this case. I just can't clearly see it. It's rotated and very small on my screen, but it looks like there's a balance sheet in the police report that is apparently supposed to document what was taken here some kind of way.
Excuse me, Your Honor. I'm at the point to where now I really want to reject my plea because that's not true. It never was no cash took. It never was no cash taken. And if they got video, that video gonna show that. there never was no cash taken out of the drawers at all at Speedway, not one time. And it definitely wasn't no $2,000 worth of lottery ticket. And if they got video like they say, then that should be that I really prefer for my lawyer to request that. So when we do go through this restitution process, I'm not being overcharged for something I know I did not take.
All right. Anything else you want to say today, ma'am?
Me?
Yes.
Oh, I'm sorry. I didn't know. No, I just want to clear that up because I don't want to be, that's why I pleaded no contest, because I don't want to be held accountable for something I did not do completely. I'm not, and I don't feel like I don't feel like I should have to pay for something I didn't do. I never took cash from them people. I never took $2,000 worth of lottery tickets. None of that stuff that they accused me of is true. And if this prosecutor got cameras, then when it's time for this restitution court hearing, she needs to produce the correct evidence that they're trying to say, because then it's going to show that it's a bunch of lies. What they said, they're not once they're going to see me taking no cash, no $2,000 worth of lottery tickets, nor no cash from Speedway, period, point blank, or no $1,200 in merchandise. That's a lie too. So I prefer for them to get that video on footage. I know they got 60 days. It shouldn't take that long. It shouldn't take 60 days to get it. So I can hurry up and pay what I do and what I am responsible for, and just put this behind me and work on me. But I can't just be like, oh, I'm about to pay this to please the next person I know I didn't take what they accusing me of.
So if I could just inquire of the court, I'm not sure if the proceedings have been continued or if there's going to be an attempt to withdraw the plea in this matter. Where are we with this, please?
My last discussion with Ms. Pitts-McGoy, which was yesterday, she did not indicate to me that she was wanting to withdraw the plea.
Yeah, that's true too, because also when I talked to you, I didn't hear that no prosecutor sitting there accusing me of a certain amount. That's not true. I also didn't hear that neither when I talked to you yesterday. You never once mentioned to me, oh, they saying you stole $1,200 in merchandise. They saying you stole this amount of cash. Never was no cash took. So it is confusing when all the conversations are not in the same circle. You got one conversation this way, one conversation this way, one conversation this way. That is very much confusing. And I'm not going to plead to something that I did not do. That's what I'm just not going to do. I'm not going to pay for something that I did not do. That's not what I'm going to do.
Anything else today, ma'am?
No, ma'am.
All right, ma'am. You're here on sentencing. And you've spoken and I've allowed you to do so. Please don't interrupt me, okay? Just so you're clear. You're here for an embezzlement charge. You did plead guilty or no contest, as you say, which does not in any way, shape, or form mean that you are disputing what is being alleged. When you plead no contest, in reality, what happens is no contest means that you accept the allegations as they're made in the report. That is what no contest means. The court gets to review the allegations in the report and accept them as true. That's what a no contest plea is. Means you're not going to say you did it. You're not going to say you didn't do it, but the court is going to treat you as if you're guilty of what's in that report. That's what no contest means. Having said that, you're here for sentencing on this today. The court is going to sentence you as follows: 365 days in the Washtenaw County Jail, credit for 1 day served. 364 days are suspended. You are on probation for 12 months. You have fines and court costs in this particular case for a total of $425. Restitution is to be determined within 60 days. You're to complete the Crossroads shoplifting program. Do not go to Speedway store in Ypsilanti. Meet with probation when and where directed, including any and all home visits. Make earnest efforts to maintain legitimate employment. No assaultive or threatening behavior towards anyone. You're to submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, or probation officer. In fact, you are to report within 24 hours to be tested for ETG as well as substances. If you have a negative, then there will be no further testing. No use or possession of alcohol, marijuana, either medical or recreational, and no drug paraphernalia, no being in the presence of anyone using that. Same is true for firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone carrying or using them. We'll do a review in 60 days. That's going to be on December 14th, 2023 at 10 o'clock a.m. At that point in time, I expect that any restitution that is being requested in this case will have been provided to this court in that request, and we'll schedule the restitution hearing after that time. If it comes in before then, that would be beneficial, and we can have the restitution hearing on that date. Any questions, ma'am?
Yes, I have a question. So, I don't currently stay in Washington County. So, and then I have another case that I'm dealing with where I'm not even supposed to be driving. So I'm trying to figure out, like, I don't have no problem drug testing, but I'm trying to figure out where would I go to drug test at? Because I can't get to Washington County. I got 2 kids and I just started a job today. So I don't know if we can work out something with me doing something in Detroit and I can try to find a ride, but I don't have no ride to get out there.
Yeah,
And I'm also not trying to violate and be taken from my kids.
you can test in Detroit, ma'am. I don't have a problem with that. So you can talk to the probation department when you call them. Actually, I'm going to give you 48 hours to test if you need a place in Detroit to test. Okay.
And I was never, and then another thing, my last lawyer didn't explain to me what the no contest was. He didn't say that y'all was going to go based upon any allegations. He said that I was technically not admitting or declining, but he was running back and forth in the courtroom that day. So he never really broke down what the no contest was, or I wouldn't have played no contest. I would have just took it to trial.
Well, I think you have to talk to your attorney about that now.
Sorry about that, Your Honor. I just got off work and it really slipped I literally just walked in.
It's okay. I just walked in too. All right. So we are here today in what is supposed to be a restitution hearing. Ms. McGoy, I'm sure your attorney did advise you that we had some discussion earlier about this matter. And I don't know if the attorneys want to place anything on the record at this time.
I'm happy to.
Okay, go ahead.
I'm happy to, Your Honor. So just to sum everything up in terms of how we got here today, Ms. Pitts McGoy was sentenced on this case. This is an embezzlement case that was originally $1,000 to under $20,000. There was a plea taken with essentially to a lesser charge during the PCC and exam stage. And that was to the 200 to under 1,000 amount. The plea form in this case does indicate that there must be a reasonable amount of restitution we paid. At the sentencing that we had in this court, there was a lot of discussion about, I guess, in confusion, I think, to some extent, with Ms. McGoy feeling like the nature of the plea that she took, which was no contest, affected how the court would see her having a conviction in this matter and what, if any, restitution she felt like should be paid or ought to be paid or that she was required to pay. There was some discussion at that time that there were some of the things that she felt like, yes, she was involved with, but others were challenged at that time. So it wasn't set for a hearing at that point, but we, at the next review date, I indicated I would go through everything with a fine-tooth comb to see what the issues were, because we had just gotten that file from another court. So of course I wasn't super familiar with it at the time. I had since done that. And so that sentencing was held in October. The following hearing, it was on October 12th. When we came back again, that was on, let's see here, looks like December. And I said at that time, I've looked at everything. It seems pretty straightforward to me. So if there is something being contested, then I needed to basically know exactly what was being contested, what the dollar amount is, what the items are, what exactly the issue is, so that we can, look into it. The total amount of restitution request that I was familiar with was $4,598 for everything. That included a number of different items, merchandise from the store, cash from the drawer, and lottery tickets. So we adjourned at that hearing in December so that Ms. McGoy could have a full and fair opportunity to review all of the discovery in this case, which includes the police report itself, documents from the store, the Speedway store, which are their accounting of cash shortages, and stills from the surveillance video that document the various things listed in the complaint. And I think a few more forms and things like that that are documents that basically account for everything that they reported. So the hearing following that was, let's see here, January 11th. And at that time, Mr. Lebo, I think, indicated that he had an opportunity to review everything with Ms. Pitts-McGoy, and that there was a request to hold a hearing because she was contesting some of those things. So I needed to know, again, exactly what was being contested so I could figure out which witnesses to call, who we needed, and what those issues might be behind those different things. So I needed that by the 16th. And we're not actually set up to have a hearing today because Mr. Lebo did reach out to me and state that he doesn't have any specific amounts or items. The general issue at this point, I'll let Mr. Lebo clarify that if I'm misstating, is that he would have wanted to question witnesses on whether the items were really taken by Ms. Pitts-McGoy or whether they were simply misplaced or lost. And so we discussed on the record, or actually off the record a bit in the breakout room this morning, those go back to the central issues from the first sentencing, which is that's a trial, right? That is determining whether or not an offense happened and whether she's the person responsible for it. So we have reconvened now to discuss where this case is, what the dispute is, if any, what the specifics are, and what needs to happen going forward. Sorry, I was so wordy, but just a big recap of everything.
I do want to clarify a few things on that for my Your Honor.
You may.
Which I think part of the issue is that I did not have a list of the specific items that were alleged to be taken. My assumption at this moment is that they're in the Excel sheet I received and that I have reached out to Ms. McDuffie regarding getting access to because it was locked by the 7-Eleven staff. So presuming that I'm able to open that Excel sheet, that it doesn't contain the list of the allegedly taken items, which I don't actually know to be the case at this point, then I think I may be able to have a discussion with Ms. Pitts-McGoy regarding those specific items. Ms. Pitts-McGoy did indicate to me that her position is she would like to have a hearing regarding the entirety of the restitution and have each item proven to be taken by her by the preponderance standard, subject to an evidentiary restitution hearing. I do believe that would be distinct from a trial because the rules of evidence don't apply to the same extent and the standard is different. However, the court did indicate that the court would prefer a more itemized list.
I did indicate that, and I'm also indicating for the record and for Ms. McGoy that if we have a hearing and it turns out that she is not making a very viable claim for not having taken those items, the court will certainly take that into consideration going forward. So, Ms. McGoy, if you want to have a hearing, it better be about real issues, because if it's not about real issues, I am not going to be happy. Do you understand that part, ma'am?
Me?
Yes, you. You're Ms. McGoy, right?
Yes.
Yes. Do you understand that part?
What you say again?
That if you're having a hearing that's not about something that's a real issue, I will not be happy.
Yes, I do feel like it's a real issue. I do feel like it's a real issue because certain stuff that, and I then tried to disclose that with my lawyer. I'm like he said, I don't know if he confused because he wasn't originally on the case, the original lawyer on the case. But certain stuff that's being accused is not, it's not true. My jaw has never been short in that job. None of that. And
well,
I want them to prove that.
You can talk through your attorney, with your attorney through all of that. And if it's not a real issue, that's going to be a problem for you. So you should have a real discussion with him. All right. So what we need to do is pick another date so that we can actually have the hearing.
Yes, Your Honor. And I just want to, one thing, Mr. Lebo, I don't have any direct sort of files of that nature. All of the spreadsheets that I have are the copies that are actually scanned into the file as PDFs. I don't have any references or any knowledge of an actual file that would have generated the error that you sent me. So if you can just,
so you don't have the Excel spreadsheet that he's referencing?
No, and I don't even see where it was like discussed from the previous attorneys or where that kind of document would exist in the file at this point.
I do have it as in our database as something that was turned over as discovery from 7-Eleven and was uploaded in September.
Okay. So we'll follow up about that offline because like I said, I don't have anything like that.
Picking a date is going to be a challenge. Okay. So either February 13th at 4, which I'm concerned that we may not finish our other matters before then, or February 8th at 4.
It sounds like February 8th would probably be the better option, Your Honor.
Okay.
My only concern, Your Honor, is that is that the date? That would be the date of the actual hearing if held, right?
Yes, correct.
So that being exactly 2 weeks from now, that brings me back to the issue from last time, which is I guess, would it be by the 1st that I need to have all of my details?
Yeah. So maybe I got one more option for this month to keep us in the same month. How about March 29th? I think that might be a decent day. February 29th. I'm sorry. I said the same month. So a completely different.
I think that's good. I think that gives us enough time to go through absolutely everything, find out people are available and get them here if we need to, and sort through any sorts of technical document problems that there could be.
I agree. There is one issue I'd like to raise, I guess, partially to see the court's position on this, which among the discovery, there is an item of stolen merchandise that is simply labeled as general merchandise. And I would hope that I could get a more specific indication of the merchandise.
I'm sorry, what now? Rephrase that. I mean, not rephrase it, but repeat it.
So among the items listed as allegedly taken by Ms. Fitzmagoy, there's a $1,200 line item that just says general merchandise. And I would like to know
if you want to know what that is.
Yes, Your Honor.
Okay. Thank you. I think that's a valid question.
Absolutely. I honestly believe so that refers to the footage of going through the store, basically filling bags with things. So I think that's honestly why that language was used on the the plea form, which was reasonable, because if that's something that's missing, obviously that would be contestable and understood. So I will find out if that gets any more specific. I'll find out if there's any way. I'm not sure that there honestly will be, given the nature of the accusation behind that, with stuff being stuffed in bags and taken out. But to your point, that may very well be something to contest. So I'll follow up.
Thank you.
Right. Because if they can't prove the amount, I mean, how do you even know which items were taken? So I think that we need to know how they're going to be able to show that they get to that particular number.